morning, and welcome to the Africa Weekly Talk. Today's subject on the docket is affirmative action. And it is affirmative action in the wake of last week's US Supreme Court's decision against Harvard University, the oldest private university in America, and the University of North Carolina, also the oldest public university in America. And in a 6-3 decision, the Supreme Court ruled that both universities violated the 14th Amendment's Equal Protection Clause. And this case goes back 2003. In 2003, Barbara Grutter, a University of Michigan's law student applicant, was denied admission to University of Michigan's law school. But in that 2003 decision, the Supreme Court upheld that the University of Michigan can still use race-based methods in admitting students to University of Michigan Law School. But then in 2006, the state of Michigan had a referendum where Proposal 2, which basically banned affirmative action in the state of Michigan. Then comes 2014, a group led by Ed Blum, Students for Fair Admission Group. And in that case, this group filed a lawsuit against Harvard University on behalf of Asian Americans. Claiming that Asian Americans were being discriminated against by Harvard University because of the affirmative action program that has been established by Harvard University. In which case, it claimed that because of the Harvard University's affirmative action program, Asian Americans who tend to have very high scores in terms of their SAT and the tests and all that stuff were not given fair opportunity to be able to be admitted into the Harvard University. And then they also filed a lawsuit against the University of North Carolina, in which case also stated that they violated the Title VI of the Civil Rights Act. So that is what basically this case that was ruled last week by the US Supreme Court was centered on. It was centered on the 2014 case that was brought by this students group, Student for Fair Admissions group. And in that decision, the Supreme Court pretty much ruled that even though that schools cannot use point-based systems or quotas, basically the affirmative action programs which have point-based systems or quotas, schools can still use a person's racial background, racial lifestyle, financial situation, basically general lifestyle of an applicant in their decision-making process. So if you look at this case was basically against the point-based systems that most of these schools have established and were using, which also happens to be more like quotas. But outside of this, the schools can still use a person's life experiences. So if you're a Black person or Hispanic or any other person, you can use your experiences in terms of your upbringing, your culture, and all of that stuff. And these schools, there's nothing in this ruling that bars them from using those experiences in their process of admitting their students. So looking at it, I think if these schools still want to have diversity in their schools, then still they can go ahead and still use these life experiences as written by Chief Justice Roberts in his majority opinion. So even though there's a lot of hoopla going on about this decision and all that stuff, I don't think this is really going to hinder the progress that minorities, black people and Hispanics have made in terms of being admitted into these universities. But there's also one thing that I really want to talk about this particular issue with regards to this decision. If you look at affirmative action programs, I would say about 90% or more of black students in American universities don't get admitted into these schools because of affirmative action programs. Most of these black students and Hispanic students, as well as Asian students, or basically every student, to me, get admitted based on their merit and other life experiences as well. So these things are already being done. So this ruling was basically against these point-based systems when schools establish point-based systems or quota systems. However, if you look at the overall programs and you look at where black people are right now, and you take this decision, you realize that this decision was basically against Harvard, which is the oldest private university in America, as well as University of North Carolina, which also happens to be the oldest public university in America. And this decision basically tells you that it was mainly centered on these elite schools in America. It is both mainly these elite schools like Ivy League schools, Harvard, Princeton, Brown, Dresden. I mean, these private elite schools who have programs like this that basically uses it to help minority students to get admitted into these elite universities. But if you study the affirmative action programs also going back to 1978, you also come to find out that most of these elite school programs basically does not even benefit the poor, ordinary minorities in America. Most of these affirmative action programs at Harvard, Princeton, Yale, Brown, and so on and so forth goes to benefit the upper class, politically connected people, black people in America, period. I mean, at the end of the day, if you look at these elite schools who tend to have these programs in their admission processes, even the fees for these schools are astronomical. That a poor person coming from a black neighborhood in America, or a Hispanic person coming from a Hispanic neighborhood or minority neighborhood in America, no way can afford to go to Harvard University, Yale University, Brown University, considering the fees alone. So for them to be even able to be admitted into these schools, either they have to have a full scholarship, or no matter how bright they are, they can be all A students with everything perfect. If they don't get a full scholarship, there's no way they can even afford to go to these elite schools. So if you look at these affirmative action programs that the Supreme Court basically deemed unconstitutional, you can tell clearly that the very beneficiaries of these programs in these elite schools are the well-connected and rich black and minority folks in America. So looking at it, at the end of the day, this program benefited only a few rich black Americans. So at the end of the day, this program, I mean, to me personally, being deemed unconstitutional, shouldn't affect majority of blacks and Hispanics and other minorities in this country. Because majority of blacks and minorities in this country tend to be admitted into these universities based on their merit. And most of them tend to go to public universities and other good universities in this country. So aside of all of that, yes, still, this does not totally say that you cannot use a person's life experience in terms of the admission process. So at the end of the day, it still can be used. And if the universities want diversity, which the universities have shown for the past 20, 30 years, that that's what built a great society, a great economy, and a great country, then definitely they will look at the person's life experiences, vis-a-vis race, financial background, family background, and all of that stuff. Now, if you look at most of these Ivy League institutions anyway in the United States, There's also something they have which is called the legacy. The legacy admitting rules, which basically is people whose parents went to these schools, as well as people whose parents or family have contributed financially to these schools, who tend to get admitted without having to have the best or highest scores in terms of when they apply for these schools. They tend to get to be admitted because of legacies. I mean, a clear example was like George Bush to Yale. Because it's his family's legacy, he was able to be admitted to Yale. And so there are a lot of programs that these schools tend to use. And these programs are used in no way violates the U.S. Constitution. But the most important thing about this ruling is about the case and how the case was brought about. Ed Bloom, who happens to be the head of the Students for Fair Admissions group, filed this case on behalf of Asian Americans. And now, I go back to ask this question. Asian Americans are supposed to be part of the, people of color coalition in America, especially when you talk about the Democratic Party. So isn't it ironic that people who are part of the people of color coalition, who haven't benefited from these affirmative action programs for the past 40 years, now all of a sudden are in coalition with white group to file this lawsuit against these universities on the basis of discrimination. Now, fellows, most of these Asians have benefited seriously, enormously on these affirmative action programs dating back 1978. Most of these Asians have even benefited more than blacks in this country. And then now they are claiming that they are being discriminated against because of the policies by Harvard and University of North Carolina. When now they think that they are in a position to be admitted fairly, now they are crying foul over affirmative action, which is all well and good. But what black people have to understand is that that so-called coalition of people of color tells you that a lot of the times when these programs come to be, and most of these programs come to be because of the Civil Rights Act that was led by black people, that was fought for by black people. And then in the end, all these minority groups come in and get to benefit these fights and these struggles that black people have gone through in this country. And then when they come to benefit from these struggles, now they turn around and cry foul over discrimination because now they think they're in a position that they don't need it to get admitted into these universities and other programs and all that stuff. Same goes with a lot of these programs, affirmative action programs, that also ended up benefiting a lot of white women. So basically what I'm trying to get to is this. If you look at most of these Civil Rights Act laws that have come to benefit minorities in this country, the very people that went through these struggles to fight for these laws and rules and regulations, the black people, the African Americans, that all these minorities come to benefit, are the very ones that in the end get left out. Because these minority groups end up building new coalitions when it suits them right to fight for something that they want to fight for. And this is a clear case example with Asian Americans going with this white coalition group to fight against the very program that they have benefited from. Their parents who came here in the 70s, 60s, 70s have benefited from these programs. I know some Indians that told me personally that they use black as their race to get access to some of these affirmative action programs. And now these are the same people who are going around saying, oh, you know what, because Our kids are scoring high in the SAT and all these admission processes and stuff. But because of these same programs that they benefited from, now they are being discriminated against. Isn't that ridiculous, fellows? But this is why Black Americans, African Americans have to reconsider these coalition groups. Because these coalition groups, at the end of the day, they always let the black man hanging in America. They always let us hold the bag after we have gone through all the struggles to help all these minorities. At the end of the day, they let us hanging. And this is a clear example of how this affirmative action ruling happened. But outside of all of that also, I will say this. At the end of the day, if you look at these affirmative action programs, like I stated earlier, the key beneficiaries, that is not the ordinary black folks from predominantly black neighborhoods or middle class neighborhoods and all that stuff. Most of these beneficiaries of these programs tend to be the upper class, well-to-do, well-connected, political connected, black, rich black families. Their kids are the ones who benefit from these things. So these should not pretty much create any setback for supermajority of black children who are going to apply for universities and all that stuff. Because at the end of the day, most black kids who are in colleges today are not there because of affirmative action. A lot of them are there because of their merits. You know, I mean, at the end of the day, these schools also have to look at so many things in their admission processes. And yes, race will always be a factor in America, as well as your financial situation, as well as your family background and all that stuff. Like Chief Justice Robert, in his opinion writing, stated that schools still have the right to consider all life experiences of every individual applicant. And if the schools really want to diversify, like they've been doing for some years now, then you look at that stuff and you look at the person, the background and where they are coming from, and that shouldn't hurt. So most of these students will still be able to get into these universities without any problem. But to make a long story short, this issue should also open the eye of these so-called coalition groups. That is where I have issue with. When you have minority groups forming these coalitions to, fight for rights and fight for opportunities, and then when these coalition groups start seeing cracks because one coalition thinks that they can benefit by going outside of coalition group, then that is what becomes a problem. And that is what we have to start looking out for. So that we have to understand that if we are going to form coalition groups, it has to be a coalition group that is going to benefit majority African American people. Because at the end of the day, it is the majority African American people who have fought for all these benefits. But all said, this is not the end of it. Blacks and African Americans and other minorities will still be able to apply to these universities, and they can use their life experiences. So, fellas, thank you guys for listening today. If it's Sunday, it's the Africa Weekly Talk. God bless you guys and have a great week. Peace and love.